One of the largest assets the American family wants to protect is usually land or their primary residence. In order to do so, many turn to a legal instrument that is called a land trust. In this video, we are going to study the efficiency or lack thereof of this particular legal document, the land trust. Greetings, my name is Patrick Phancao with the Asset Protection Center. I am an estate planning attorney focused in the field of asset protection and elder law out in the state of California and Florida. So let's look at a land trust and how it functions. First and foremost, the concept is that you are the grantor, the individual that created the trust, and you are assigning your interest or benefit to a trustee, the individual that will govern the asset within that legal document, which for our particular example is a primary residence. So what are some of the issues within a land trust? Well, first, it would be considered a self-settled trust, which is a form of instrument that is not recognized for asset protection purposes in the U.S. court. So why is that? You are the individual that created it, you are the individual that benefits from it. So in essence, it is one and the same, and so there is no distinction between you, the individual, and the asset for collection purposes. So the argument often stems from the fact that I created the land trust, but I am not the trustee, the individual that governed it. So what are the other issues with that? So if they want to create a sale so that they can state that the trustee actually owns the asset, well, there's the classic argument of fraudulent transfer, that this was not a arm's length transaction or that you did not receive fair market value for the asset that you quote unquote sold to the trustee. That's argument number one. Argument number two, assume that you actually do a real sale. Well, then you are going to incur some sales taxes that you probably did not wish to create in the first place. And finally, in the bankruptcy context, you need to have what is called a 10-year look back. Meaning, if you are going to create a land trust and file bankruptcy and say that this land trust is not yours, it is not an asset that belongs in your spreadsheet of assets, well, you need to have a 10-year spread difference before a bankruptcy court does not drag that land trust into the bankruptcy court. So you can tell there are a lot of complications with it. And finally, the concept of illusion. A lot of clients come to me and say, hey, at least with a land trust, they will not know that I own the asset. And in real life, if you are brought into a lawsuit, it is not, or it will not be difficult for a creditor to find out sooner or later that you are residing in the land trust to which you are the beneficiary and most likely the grantor. So that concept of privacy is kind of an illusion because it's at best a delay tactic. So all in all, a land trust to me at best is that it's a delayed tactic within the asset protection universe. Would it protect you at the end of the day? I do not believe so. I mean, naturally, there are a lot of different opinions, just as with anything, but my personal take is that a land trust is a delayed tactic, but not really efficient for asset protection purposes. I hope you found this helpful and not too complicated. If you want to find out more, visit us at assetprotectioncenter.com, or if it's a pressing matter or you have a question that you can't quite figure out, call me 714-966-2646 and I'll be happy to discuss your situation. Thank you for watching and I'll see you next time.